So once again, good evening, everyone present over on the virtual session today. So today's session is being organized by Janata Education Society and Vivekananda College of Law and its Alumni Association. And I welcome everyone. Today's session will be litigation, beyond litigation and into corporate sector. So it will be delivered by Srinivas. So before we kickstart the session, I may call upon the principal sir to give a brief introduction and welcome the gathering. Please vote you, sir.
Thank you, Raghavendra.
Yeah.
Good evening, friends. It's my pleasure to welcome all of you for this virtual platform for this webinar series. Today we have amidst us Shri B R Srinivas, partner of Dua Associates, Bangalore, who is an alumnus of our Vivekananda College of Law. He has enrolled in the Bar Council in the year 1988. Shri Srinivas is specialized in corporate real estate sector, and his services include transaction advisory, advice on investments, acquisition, debt and financing of real estate transactions. His expertise includes title due diligence of land, especially for large tract developments and acquisition of land for renewable energy projects. Srinivas also has significant expertise in various aspects of corporate law, ranging from general corporate advisory, investment and acquisition transactions. He specializes in fintech infrastructure projects, specifically in renewable energy, food law matters, and intellectual property issues. Further, Srinivas has immense expertise in labor and industrial law related matters. It's my pleasure to welcome Shri Srinivas to speak on the topic beyond litigation and into corporate. Welcome. A warm welcome is reserved to you, Srinivas sir.
Thank you, Kempegauraji.
Yes, and then we have amidst us today.
Mr. Shivanna, can you please mute yourself? Mr. Shivanna, please mute yourself. Madam, can you mute him? I am unable to do it.
Even I am unable to do it, sir. Even I am trying.
Okay, please, sir.
Right, we have amidst us the office bearers of Janata Education Society and the members of Janata Education Society and members of our governing council, professors from various other institutions, students from our own institution and other institutions, my dear colleagues, and most importantly, my members of Alumni Association and all office bearers of our Alumni Association, because I am indebted to you, because you people are extending helping hand to me to organize this program. A warm welcome is reserved to all of you. Once again, I welcome all of you because it is a joint venture by Janata Education Society's Vivekananda College of Law as an IQAC initiative. It is a mandatory for our institution. In case if you want to go for NAC, then it is an IQAC initiative. We need to organize this type of lectures or webinar series. It is helpful for us to share knowledge, and moreover, it is data regarding the various resources available in our alumni, and at the same time to make use of their surveys for the growth of the betterment of my institution. With this, I welcome each one of you to today's session. I welcome one and all. Thank you. Over to you, Raghavendra.
Thank you very much, sir. So, just quickly, session is going to be for 45 minutes, and at the end of the session, we're going to take few questions, depending on the time slot. So, today's session is very much useful for the students especially, and of course to us also. And I call upon Mr. Srinivas, one of my close friend and a very good speaker, a very knowledgeable guy. So to take over the session, please, sir. Session is
yours. Thank you, Rajendra. Yeah. Namaste, Elrigu. Kempe Gowdaji, thank you for this opportunity. I also thank Vivekananda Law College, Janata Education Society, and of course, VLC alumni for this opportunity. I thought this will be a very good platform and an opportunity to share my experiences with all of you. And in the course of it, if it's found useful, nothing can be more happy about that. So the topic that I'll be speaking about today is beyond litigation and into corporates. See, the general perception about a lawyer, if you would say, would be that a lawyer is an advocate who practices in court, a lawyer who is in the litigation practice. But the endeavor here is to introduce you to the realm of practice beyond litigation. Okay. Just a moment, I need some support in the presentation. 1 minute.
We can see your slide, Srinivas. You can just go ahead. You can just click next.
I'm unable to move the slide. Once. Can I think the co-host sharing is not appropriate, maybe?
No, sir, it's appropriate. I have given the power, sir. One second, I'll check.
No, madam, Sulpa.
Now it's working. Yeah, it's working.
Yes.
Okay.
Yes.
Thank you.
Thank you. Right. So let us examine who is an advocate. Okay, if you look into the definition of an advocate in Black's Law Dictionary, it says advocate is a person who practices in open court. And if you sorry. So if you would look into the definition of an advocate under the Advocates Act, there also it merely says an advocate is an advocate who is enrolled as per the provisions of this Act. So really, if you see, the focus is on a person who is practicing in court as an advocate. Okay. Now, as lawyers, I think it is only fair to say that we really like litigation. We practice in the area of litigation, fairly so, because that's our area of work. But the question that arises is, does the society, like litigation? Obviously, the society would not like litigation, isn't it? Right? The society would want to go on with its life without actually indulging in litigation. So that is where the importance of a lawyer in not litigating arises. And that is what I would like to introduce to each of you, to see how the lawyer has a significance in outside of litigation, to minimize litigation and to ensure compliance. That's the endeavor of this presentation. Okay. For instance, to speak colloquially, let's say take a situation where you are suffering from an ailment, you go to a doctor, you are cured, so you really feel indebted to the doctor because he's cured you. But today, if you really look at it, we are also in a situation where we feel equally indebted, let's say, to our yoga teacher who makes us stay healthy and is avoiding any ailment or ensuring that we stay healthy. So this is the side of practice which today has a lot of significance, because the society and the business community in general, the corporates do not want to litigate. They want to focus on their business. They want to improve the economy. They want to focus on what they are intended to do. They don't want to get into litigation. So from that point of view, let us understand who is a lawyer. Is it different from an advocate, or is it the same? If you look at the definition of a lawyer in Black's Law Dictionary, it is defined as a person who is learned in law, an attorney, a counsel, a solicitor who practices in the area of law. So it's a much more wider definition, It is all encompassing to say that a person who advises you in law, who counsels you, and who provides you the appropriate advice from a legal perspective is a lawyer. So in that sense, if you really look at it, an advocate is a subset of a lawyer, which only goes to show that the practice of law is a larger area and litigation is one of the areas of practice, right? So it is important to understand, like I said, why does the society does not want to litigate, and where does a litigation or a dispute arises? Okay. Apart from, let's say, government-related litigation, most disputes arise out of transactions. I want to sell something to you, or maybe we want to get into a joint venture, we want to do some business arrangement, and that is when a issue arises between us where there is, let us say, a failure to pay the consideration, there's a breach of promise, non-compliance to law. These are some of the situations, misrepresentation. These are some of the situations when a dispute arises. And that is when the realm moves into litigation. So therefore, the focus today from the corporates and the business sector is to ensure that there is compliance to law beforehand, and second, there is minimum opportunity for litigation. Of course, if parties don't fulfill their commercial obligation, well, there will be dispute, but keeping that aside, which of course we lawyers cannot control, if you really look at it, there are all these surrounding factors which, if checked appropriately and conducted in a very synchronized, orchestrated manner, there is the possibility to minimize litigation and ensure compliance. So for that, we need to first understand what is the role of a lawyer in a transaction, because that is where issues arise. So what is our role? Okay. Now, our role as a lawyer in a transaction would be to guide the parties in a manner where all activities are in a way with the objective of compliance and avoid issues. Okay. So if you segregate the transaction role for a lawyer, it would comprise of the following sectors. One is due diligence, structuring of the transaction, drawing up of the contracts, and closing of the transaction. These are the four critical elements where a lawyer has a role to play in any transaction. Okay. Now, I wouldn't be able to explain the role of a lawyer in this transaction unless I take an example of a transaction and explain the role of the lawyer in the segments which I just now explained. Okay. So I have taken the example of a transaction which is slightly complicated, but unless these are some of the facts which I bring to your notice, you will not understand the significance of a lawyer, because it is only when there are complications does the role of a lawyer become all that more significant. Okay, I'll try to keep it simple and explain to you. If any of you would not have understood, please, you can later ask me about it. So this is a transaction where ABC is a company which owns a land parcel. ABC has entered into a contract with XYZ, which is again a company, to set up a solar power plant for ABC at the land parcel owned by ABC. This is a simple transaction. The only difference being that ABC will not pay XYZ up to the time the contract obligations are fulfilled. The solar power plant is set up and delivered to ABC. It is only then that XYZ will get paid. So XYZ has to put up the solar power plant at its own cost. Okay, that's the basic relevant facts here. Now the situation is that XYZ company has already put up the plant and it has fulfilled its obligation. Now it is found that ABC does not have the resource to pay XYZ for the contract obligation fulfilled. So the parties now intend to enter into another transaction where they want to enable the payment to XYZ. So the transaction that is agreed between the parties to enable payment to XYZ is that XYZ will be made a 50% owner of the solar power plant, which will compensate XYZ for the consideration payable to XYZ. Okay. I'll repeat again. The arrangement is that ABC will make XYZ company 50% owner of the power plant, such that the consideration payable to XYZ is taken care of by giving it ownership over 50% of the plan. On top of it, let's say about 10 crore rupees is payable by ABC to XYZ as additional compensation. This is the arrangement agreed between the parties. Now, this has to be given effect between the parties as a transaction. Okay. So now here is where the role of the lawyer comes in. Again, we go back to what I said, the 4 elements of due diligence, structuring the transaction, drawing up of the contract, and closing. Let us assume that we as lawyers are acting for XYZ company, which is the recipient who is entitled to the consideration by way of ownership over the solar plant. So the first thing that the lawyer would have to do is to do a detailed due diligence of the solar power plant and ABC company, okay, to see what is it that I am getting it. Okay, the next is structuring of the transaction, then drawing up of the contract and closing. I'll explain each of these activities and tell you how a lawyer's role is so significant that without the lawyer, it cannot just actually happen. So in a due diligence, what will I check in this transaction? I'll check if the title to the land parcel is valid, if there are any charges of any third party to the land or to the solar power plant, if there is any hypothecation or any other charge of a third party, if there are any borrowings to which ABC is liable, dehorse this transaction, but nevertheless will have an impact on this transaction. What is the stamp duty or tax implication to this transaction? How is it that the parties can minimize? This, by and large, would form part of my due diligence. Okay. Next, I will have to structure the transaction. Okay. A simple way of conveying 50% ownership over the solar power plant and the panels to XYZ would be to execute a sale deed. Okay. But a sale deed has its own challenges because one, it will attract stamp duty at 7% if it's in Karnataka, and it will attract income tax capital gains, and there are other GST issues and other obligations. So that may not be the most appropriate way to give effect to a transaction. See, remember that ABC is already in a position where it cannot pay the money to XYZ. So by burdening it with other liabilities, duties, taxes, it will not be a proposal which is acceptable to ABC, right? So you have to come up with a solution where the requirement of both parties are met, and so you come up with a structure. So the structure which we could think of in this transaction was that we set up a limited liability partnership, okay, which we have called here the special purpose vehicle LLP. Now, ABC will contribute this plant into the SPV LLP as capital contribution, which does not entail any stamp duty, it does not require any instrument, a mere contribution deed or reconstitution of the deed is sufficient. So today, the owner of the solar power plant is SPV LLP, majority partnership held by ABC. Then what we do, there is a money payable to XYZ by ABC. That debt is also transferred by XYZ to the SPV LLP. That means instead of ABC becoming liable to pay, XYZ becomes liable to pay to, SPV LLP becomes liable to pay to XYZ. So therefore, the debt is on the head of SPV LLP to pay off XYZ. So instead of paying XYZ, what SPV LLP does is to convert the debt into partnership interest. That way, there's no dues payable to ABC, XYZ. XYZ also becomes 50% partner in SPV LLP by writing off the debt payable to it by SPV. So in this fashion, what we have done is to come up with an arrangement which is tax friendly and stamp duty friendly, yet achieving the objectives of the parties such that they can actually give effect to what they had intended. Okay? Transactions are driven by such intentions, but I'm giving you an example so that you understand what today's commercial requirements are and what needs to be done to consider an arrangement where it meets the requirements of parties, yet be within the four corners of the applicable laws. Okay, so I'll again explain. In this fashion, the debt payable to XYZ has been written off. Instead, XYZ has become a partner in the SPV LLP, whereby it has 50% ownership. That way, today, the owners of the plant are ABC and SPV XYZ through the SPV LLP. They being 50% partners, the SPV LLP is the owner in law, but the actual interest is held by ABC and XYZ. This is the structuring of the transaction, which again, a lawyer and a tax consultant have a significant role to play, and without their involvement, this cannot be evolved. Okay. The next is you have to drop the contracts. So to give effect to this transaction, what all documents you will need? You will need to drop a constitution document for the LLP. Then you will need to do a business transfer agreement for transfer of the power plant from ABC to the SPV LLP. You need to assign the debt. You need a document for that. Then you need to reconstitute the firm to make XYZ a partner. You have to take care of borrowings. You need to have an arrangement to pay off to receive payment from the bank. So these are, I've illustrated some of the documents that will have to be drawn up for this transaction. So again, the person who dropped these contracts obviously is a lawyer. Again, there is a significant role for the lawyer to ensure that these transaction documents are drawn up to serve the intent of the parties, ensure compliance to law, and also ensure that there are no opportunities for any non-compliance or breach of obligations. To the extent possible, bring in commercial checks and balances such that the parties fulfill their respective obligations. Thereafter, once these documents are drawn up, they are signed, and you do the actual closing, which means you give effect to what was intended. Okay. So
Sir, mute agidira. Please unmute yourself, please. Srinivas ji, please unmute.
Can you hear me now?
Yeah, yes, please.
So I would like to draw attention to one of the contract here, which is a little different from the usual as well, okay, which is the escrow arrangement. Okay? Again, I want to bring to your notice the significance of the lawyer in bringing about a transaction. So an escrow arrangement is a document or an arrangement between the parties and an escrow agent, usually a bank. So like I had mentioned some time back, that there is a 10 crore cash payment which is funded by a bank. So the fear that XYZ would have would be when the bank gives a loan of 10 crores to ABC, what if ABC does not make that payment to me? So you arrive at a escrow arrangement whereby ABC instructs the bank to make payment of 10 crores directly to XYZ, and the bank treats that payment to XYZ as a loan to ABC. So the payment is to XYZ, but it is a loan to ABC. By this fashion, when the closing of the transaction happens, the payment comes to XYZ without the fear that ABC may refuse to make payment once it gets the money from the bank. Okay, so this is an escrow arrangement, which is a little unique from the other arrangements. And today, the escrow arrangements, let me tell you, I've given you a very simple example, have evolved into complex arrangements, especially where there are multinational transactions where payments of money have to happen across the border, across various countries, and these arrangements gain a very high significance and importance, and they have to be done in compliance with FEMA and the foreign exchange control laws of the overseas countries, and ensuring at the same time that the transactions are fulfilled. So again, the lawyer has to apply his mind, ensure that the concerned law is taken into account. You're not drawing up a contract in breach of any law, and yet meeting the requirement of the parties. Okay. So this, if you see, is an arrangement where a transaction has been given effect through contract and the closing. Okay. One moment. I think I cannot again move the presentation. Is there some concern? Yeah, now I can. Yeah. So now that we have understood the importance and significance of a lawyer in a transaction which is outside of the realm of litigation, and you realize that today litigation practice, with due respect to all my litigating colleagues, is probably 1/100th of the practice. The 99% of the rest of the practice is outside of the courts. As the economy has grown, things have become complex, things have become more evolved, more synchronized, and therefore the role of a lawyer outside of the court today is so enormous, significant, complex, and critical that you have multiple lawyers working on various facets of the transactions. Okay, to give you an overview of the categories of practice, okay, which is outside of litigation, you could say real estate, private equity, M&A, intellectual property, labor, infrastructure, banking, NBFCs, regulatory advisory. There are many more. Okay. There are law firms which practice exclusively in each of these areas. There are lawyers who practice exclusively in each of these areas, and they are in themselves a vast area of practice. I can give you a small example of the areas of practice where I am involved in. Probably I can say more than probably the other areas. Okay. The role of a lawyer, let's say in real estate practice, is to put it in a nutshell, title due diligence and transaction documentation, drawing up the documents and closing those. And some of them, as you must be aware, are joint development agreements, lease deeds, sale deeds. Okay, but see, the arrangement today is not simplicity of a real estate transaction. Today, the real estate is merely an underlying asset to a larger transaction. Okay, I'll give you an example. See, we've quoted this example where happens to be our client, Acres Infrastructure, acquired 300 acres of land at Koppal to set up a toy manufacturing cluster with about probably 100 to 150 vendors and large manufacturers coming together at one location to manufacture toys. The objective of this arrangement was to set up a manufacturing cluster which would be far superior to what is presently available in China, and we will be competing with China hands down. That was the arrangement and the intent. In fact, it was inaugurated by our Chief Minister, and we helped in the diligence and in enabling the transaction. And look at the benefit to the society. Okay, the estimated employment around Koppal, which is in the back of beyond of Karnataka, is for about 15,000 people, direct employment. And there is a revenue generation which would run into a few hundred crores. And there is indirect employment and value addition to a backward area in the state. So on the face of it, it would look like a very ordinary acquisition of land, but really it is a transaction which has a lot more impact on the society. And that is why we as lawyers have to realize that the impact, the productive impact to the society is far beyond what we can envisage in this area of practice. In fact, this transaction was done by my partner, who's a lady advocate, so you can understand where as practitioners we have come. So another transaction we have done is about solar power plants being acquired, for which thousands of acres of land were acquired. Plants have been set up. Today there is power generation and there is significant impact or positive impact on the society. There are many such transactions which have happened in the real estate sector, which I have not listed here, but I'm sure you've all read in the newspapers. Take, for instance, Blackstone acquired all the assets, commercial assets from Prestige in an all-cash transaction, which was one of the biggest transactions of last year in the country. Now, just imagine we were in a pandemic year, and in a pandemic year where all of us were struggling, the lawyers involved in that transaction did not have any time to think of anything else, because it was such a large transaction in which not less than 200 plus lawyers were in. So this is an area which, beyond what we would, imagine in the ordinary course. It may come across as news in the newspaper, but if you think about it, the role of a lawyer in each of those activities is significant. Okay. So similarly, there are merger acquisition transactions, private equity transactions, some of the transactions we have done. Another partner of mine who did this transaction where Sachin Bansal acquired a NBFC entity, which was a very large transaction. Then I'm sure you're aware that Facebook invested in Geo platforms. Then Zomato acquired Uber Eats from Uber, which was again a stock deal transaction where shares were exchanged, and it's a 350 million transaction. All this happened again in a pandemic year. So imagine the activity happening on the other side, which involves lawyers end to end, and without them, none of this will happen. That is something you must be really conscious to. So the deal size in India, just to give you a perspective of the deal size in India, is M&A transaction in a pandemic year was 43.5 billion US dollars. So 1 billion USD is 10,000 lakh. 1 billion is 10,000 lakh. So the merger acquisition size in India last year was 43.5 billion US dollars. And the foreign direct investment in India was the highest. And as of December, it was 67.5 billion US dollars. So you can imagine the impact on the economy and the role of the lawyer in this entire activity, how productive we can be, or we are already in these transactions. Okay. The other areas of practice, just to give you an overview so that you understand what are the sectors in which lawyers are practicing today, are capital markets. You see the companies getting listed day in, day out. Now, when you do a listing, you must understand that a company has to undergo diligence by none other than the SEBI. So they have to come up with a diligence document where they show all disclosures. SEBI reviews it, approves it, and that's put up in the form of a red herring prospectus before people subscribe to the shares of the company. So what does this prospectus set out? It sets out what the company is, what are its profits, what are the drawbacks in the company, what is it that the company has done right, what is it done wrong, and all that is reviewed apart from merchant bankers by lawyers. And only when the lawyer signs off can the listing happen. So therefore, without the lawyer's involvement, today, trust me, there is no listing that can happen. Another area is intellectual property, which has evolved big time. You are now reading about the platforms, intellectual property, IT, they go hand in hand. And even otherwise, copyrights, trademarks, technology transfers, know-how, they have significant importance in today's economy. And you will understand in this pandemic times when vaccine is the most critical drug available, what the value of the intellectual property to that drug is, right? So although we are manufacturing that in our own country, we don't have the rights to manufacture them at our whims and fancies. We are bound by various obligations. So that is a critical area again where a lawyer plays a very significant role. Labor practice, I'm sure all of you are aware, and today we may not have as many manufacturing sectors as we probably had about 2 decades ago, but even from an IT industry perspective, labor has a lot of back the stage role to play, because the HR policies are drawn up in such a way that you will be amazed that these companies are so keen to ensure that they comply with the law to the T. It is not as if they have an attitude to brush over and do things without compliance to law. A lot of litigation does not arise here. Labor disputes do not arise here because the management is also very focused in ensuring compliance with law. And there again, the lawyers play a very significant role in advising the company how to comply, what are the options available to them, how is it that they must look at it, what is it that they must comply with, and what are the rigors of compliance. A very significant role we play there. Infrastructure area is another area of practice. All you see is road concession agreements for the highways or power. All these are another area of practice where there are specific documentation for each of these activities. I practice on the power side, so I can tell you what is drawn up is documents such as a power purchase agreement. Now that is a document which sets out how power will be generated and supplied to a third-party purchaser, and how the power is routed through the grid, what is the wheeling and banking charges you pay to the distribution company, what are the approvals you need, how is the metering done, how is the payment received, what happens if there is power failure in the grid, what happens if there is a failure to generate power, and how do you take, how do you get into in-house generation of power. These are some of the areas of practice which are complex. Specific laws are applicable, and the specific knowledge of the industry must be derived, and only then you could probably practice in these areas. And that is an industry in itself, right? You have regulatory advisory, be it the SEBI, RBI, or National Housing Board related to these. Then you have NBFC, banking. See, here I'd like to focus on something which has evolved because of the startups, which is something nice, and the Reserve Bank has also been up to speed to live up to the present time. So what they have done is to create at times what is known as a regulatory sandbox. Now this is an activity where there are no stringent laws. The RBI comes up with a very flexible, broad framework laws. Then the relevant industry or the company which is involved in that activity complies with those framework of laws, yet they try to make certain modification within the framework to suit the business. And they suggest that to RBI to say that, look, this is how probably we'll have to do it so that the business objective is met, yet the objective of compliance from a larger perspective is also met. So the Reserve Bank and the key players in the industry have an interactive mode of evolving laws for that particular sector. So this regulatory sandbox has proved to be very effective, and the lawyer's role is important here because they are the ones who guide either the RBI or the industry players on what the framework should be, what the modifications can be, yet remaining within the larger framework of ensuring that the common man is not affected. So we have evolved to a situation where we are framing laws on the go. It is not that the laws are framed and then you get into business. You start your business, you realize that there is a lacuna in law, and then you frame the laws. I mean, when Ola started their business, there was no law regulating such platform cabs. But today, there have been various guidelines which have evolved over time. So today in this area of startups, in this world of startups, a lawyer again plays a very critical role in evolving laws and complying with laws. So some of the top law firms in our country, just so that you get an idea that today it is a very well-organized area of practice. It is more or less institutionalized. Okay, of course, you can see the name of my firm, Dua Associates, and there are other law firms as well doing some of the largest transactions in the country. Whilst we are organized and institutionalized, but if you look overseas, abroad, they are that much more well-organized, evolved, and already they are institutions and industries in themselves. Some of these are Baker McKenzie, DLA Piper, and some of the names I've given here. You won't believe each of these firms engage 2,000 to 3,000 lawyers in-house as lawyers of the firm. So you can imagine the size of the transactions that they are carrying out across the globe. They have branches across the globe, multiple lawyers, multiple locations, and all working towards transactions which are interlinked, may not be interlinked at different locations, all going by a common agenda, a common platform, a common ethos. So the manner in which these practices have evolved today is as good as any other industry. Okay. So what I would like to say is that today the role of a lawyer is of an enabler of the economy. What we must know is that we must step outside, see the larger world that is out there for a lawyer, the role that he can play in evolving the economy, enabling the economy, and really be a key player in nation building. That is the significance of a lawyer today. So as students from our college, I'll be very happy if each of you understand this larger world of lawyers that is there. And of course, there's nothing wrong with litigation. It's an awesome area of practice. I have practiced litigation myself for close to 3.5 years. But there is also another world which is waiting there for you all to explore, understand, be a part of the economy, be a significant driver of nation building. So that is where I would like to close this session from my side. Please, if any of you have any questions, any clarifications, I'm happy to take. I think I've finished on time, but I'm happy. I'm here.
Yes, you have finished it on time. I'm very grateful to you, in fact, on behalf of everyone. Srinivas, quickly we'll take some questions so that we can proceed further. I call upon Pratima Honapura. She has a question to you. Pratima, can you unmute yourself?
Yes, I have unmuted.
Yeah, please go ahead.
A great session, Srinivas. We're thrilled to have you in our webinar series and
Thank
a very
you.
different topic today. Even as academicians, students, and as practicing professionals, it was a great insight to a world which we are not in touch with much, though we are a part of the litigation. So my question to you would be that of course, we have a very strict syllabus which the students of law go through in the university. So as a person who practices on non-lit side, what would be your suggestion to the academics to expose these students to law beyond litigation than just the courts? So what they can include in academics and how they can encourage these children to understand there is something beyond litigation in the profession. So what would the suggestion be?
Thank you, Pratima. Yes, we are all aware that when we studied and we passed out, we were really not as much aware. But today, there is a lot of awareness. But from the academician's perspective, the activity that they could do is just the way they help the students to undergo moot court. They should also probably make provision for them to understand the corporate or non-litigation side of the practice. It should be given equal importance where they are given assignments to maybe interact with practicing lawyers or intern at law firms or any other law offices, and probably do a project on the practical implementation of law. So that if that is possibly made one of the activities for which a certain number of marks or grades are set aside, it will really help the students to move into this and understand this and be better prepared as they come into practice.
Thank you.
Thank you so much.
Thank you, Pratima. Srinivas, every contract will have 3 stages in its life cycle: making, living into it, and ending it. If it ends up normally, then okay. Otherwise, it will come to lawyers. But when people or parties live into the contract, then the real reality, like real rights and responsibilities, everything sprouts. Now, do you advise whether students? I mean, a law student is almost a lawyer, not an advocate. So, do you advise that law students should get into all these authorities who are involved, say, as you said, power sector or technology companies, or even data mining companies or data sectors? That students should visit them rather than going to law firms or elsewhere or to the court, they should go to these authorities who grant licenses, etc. Is that a suggestion to you? I mean, you advise that to students, or how it can be done in case if it is possible?
Well, Raghavendra, I wish this was true. Authorities can definitely disseminate a lot of knowledge and practical solutions to the students to learn from. But I really doubt whether in practice it will work, because the authorities are busy and they have their own responsibilities, and for them to take this up separately, the students may find it difficult. Instead, like I said, if the students gain exposure to particular areas of practice, and in that process also meet the authorities, then it could possibly be more well-rounded rather than go to the authorities directly, because the students will have a context to go to the authorities, and the authorities, I'm sure, will be happy to give them clarifications and explain to them how the systems work, so that they have a context to explain and provide a clarification. That is my view.
Thank you, Srinivas. Just move on to the next question. Our Professor Kalpana Madam, she has a question to you. Sir, what's more challenging, litigation or non-litigation? A straight question to you.
I have done both, okay? Straight and a difficult question. Thank you, Kalpana Madam. As you would do in college, you posed a difficult question.
True, very true.
Well, if you look at it this way, okay, what do I give priority to? Do I give priority to myself, or do I give priority to the society? If I give priority to myself, in a way, I would think litigation is more satisfying, because you play a significant role in the court, and the happiness that you get is in being able to demonstrate to the court why your client needs to be given the relief that you are praying for. Okay, nothing wrong with it. Well, that's the way it is. Okay. However, in a non-litigation practice, what you do is, of course, behind the scenes, but the impact of what you do is far more significant. See, one is curative, the other is not just preventive, is also an enabler. Okay, so today, if let us say you would see an industry which has been set up because of the efforts that you have put in, the satisfaction that you would get from that, I would say, is far more, at least for me personally, than I would get maybe by winning one particular matter. Because again, there's another appeal, an appeal after that, there are other issues, and what I have done may possibly be not the end of the road. However, in this area of practice, that more or less is the end of the road, where you have culminated your efforts into something concrete and significant, productive for the society. So in that sense, I would say non-litigation practice gives more satisfaction from a society benefit perspective.
Yes, Srinivas, I'm so happy that you've given us the holistic perspective of law and how lawyers can help in the building of the economy of the country, nation building. You have ended it so beautifully. Compliments to you. You are doing great, and it was a wonderful session. Kindly carry on. It has been very, very interesting, and I'm sure it'll be a lot useful to our students to choose career-wise. Thank you so much.
Thank you, madam, with your blessings always.
Thank you, Kalpana ma'am.
We would have asked Kalpana madam to deliver vote of thanks, perhaps. Yeah.
No, sir. That is the prerogative of the host. That is the prerogative of the host.
Okay, right.
Srinivas, just to add one more question, do you suggest that a student who pass out law can look into both litigation, non-litigation, both, in case if it is possible? Which are the areas that you feel is appropriate that can be looked into by a lawyer, along with this litigation, some non-litigation also?
Just a moment. Well, see, it depends on the clientele, of course. He or she would have to be dependent upon the type of clients they are dealing with. There's always option to do both, okay? It has been happening traditionally, at least in the areas of litigation and real estate, where our lawyers have managed both very well. So that is an immediate area where they can do both. But otherwise, let us say you are practicing in a particular area like intellectual property or related areas, then for you to have the ability to do work outside of litigation will also be significant. Let's say if you're registered as a licensed patent attorney or you have a practice in the copyright sector, then you can do both, definitely.
Thank you, sir. Thank you very much. Professor, I believe K. Shivaprasad, sir, I believe, has asked a question. Sir, are you there? You can unmute yourself and ask. Okay. Nobility of the profession and commercialability of in rendering services on non-litigation side, how it's compatible?
Can you come again, please?
Nobility of the profession and commercialability of the rendering in rendering service on non-litigation. What is the compatible mode of both?
You charge your fee to the client, Raghavendra, you charge the fee to the client, then do pro bono service to the society for who deserve. So that way you're meeting both objectives.
Thank you so much. There is a question from Sodha. She asked, Sodha asked, sir, kindly let us know what would be the impact to XYZ, the illustration that you accentuated, if it is in a case of section 9 of IBC, Insolvency Bankruptcy Code, I believe, before consideration paid by ABC / couldn't operate LLP within 1 year from the date of incorporation. Probably what is the effect of bankruptcy code in case if something goes wrong is the intent of the question. Well, that is also an area.
Correct. So here in the example that I gave, I had suggested a business transfer arrangement. What you could also do is to approach the NCLT and make a scheme for restructuring. And if that scheme where you effectively do the same thing, but with the blessings of the court is approved, then the possibility of challenge to that process does not arise, number one. Second, this is an arrangement where the parties have already amicably arrived at a solution. So therefore, the challenge to it as a debt payable, admitted due, and seeking a resolution plan does not arise, if that is what you seek to understand.
Thank you. Anil Kalgi asks, great session. Is the role of corporate advocates are compliance to or acting to change law?
Well, sorry.
Do they play a role in changing the law because they do only non-litigation?
The role in changing the law would be indirect. Like for instance, we advise a few governments in formulating policies and the laws. They come to us, they request us as an assignment to prepare policies for procurement, prepare policies for various government activities such that it is done in a fair and judicious manner. And if it is challenged in court later on, they withstand the challenge so that there is no hindrance to the objective that they want to serve. So in fact, it is so evolved that the governments have a tendering process where law firms have to bid, and the successful law firm is given the assignment to formulate the policy. So in that sense, it is much beyond than what a single case could achieve, because we are actually advising the governments to formulate policies which are in compliance with laws.
Moreover, I think legislative impact assessment also is possible in the process of knowing the contractual nature of the transaction. So probably it will be great while writing the conclusion as to how the law is going to be effective. Yes, thank you so much. Valli Chaudhary asks, But sir, if I may, there are not many law firms that practice in divorce cases, criminal cases, cyber law, and medical law. So a layman does have to go to advocates, and there will be a lot of legal work, which is intending that layman knows all these things, need not go to court.
Well, in the areas of practice that you mentioned, matrimonial matters, law firms by and large focus on commercial areas of practice, including litigation. What practice we do are to do with the commercial areas of practice, arbitration or otherwise. Matrimonial matters, the law firms generally do not take up. Yes, in that sense, you may not be able to go to a law firm. Cyber security, today, a lot of law firms do provide solutions and advisory in that area. We do as well. We may not have a special cell for that, but I think the time has come where that will evolve in the next few years. I think that will be an area in practice in itself to a good extent.
Thank you, Srinivas. Shall I take one or two more?
Of course, I'm fine, as many.
Yeah.
At least I know someone has listened to what I've said.
Yes. I mean, it's a great session, I should say. Shreyas R asked, how would one transition to an in-house transactional law firm, a law firm? Which one is better, transactional law or not?
Well, the question is a little mixed up, but let me clarify to you. There is an in-house counsel, in-house lawyer who works in a corporate as an employee. Then there is a practitioner outside of the corporate who is licensed to practice law as any other lawyer, but is not an employee of the client. Okay, so both play different roles. Okay, the in-house lawyer is more involved in day-to-day legal management, whereas the external lawyer is involved in advisory on a case-to-case basis. That is the difference. So you can always migrate from one to the other, depending on what you think would be what suits you.
Okay, thank you so much. I think somebody has raised a hand. There's no name on that. Please, you can unmute yourself and ask the question. Yes. Please go ahead. Go ahead. Please ask the question.
Hello, sir. Can I ask now?
Yes,
so,
yes.
In a construction company or a company which produces these beams and the columns and all, when we conduct the due diligence, there is a chances that some documents may not be available, like the sketch of the plant or anything. So how should we go further when the documents are not available?
Well, a relevant question. Okay. Well, one is, of course, you can only opine on what is provided to you, and you cannot opine on what is not provided to you. Your duty is to ask. And alternative could be to check with the concerned authority whether the relevant document is available with them. Like, for instance, in the example that you gave there in the manufacturing of beams or steel rods, obviously the factory layout plan would be approved by the factory's inspectorate, and you can always make an application to the inspectorate of factories to provide you a copy of that, or you can visit their office to inspect that to see if they have indeed obtained the license for the factory, if it is built as per the applicable law, and thereafter take a view.
Okay. Thank you, sir.
Thank you, ma'am.
Thank you, sir.
K. Manojana
yes, sir.
asked. Yeah,
yes, sir. That's me. That's me. That's
okay. Yeah. In case if there is no documents, okay, fine. I think, sir, we can go to the next move. I think there are no more questions.
Yeah.
And time is also up.
Yeah.
So
I'm happy that.
Yes, sir, please.
That. Just a minute. Now, thank you very much, Srinivas ji, for enlightening us on the opportunities available for the young generation other than litigation. And then I am, I congratulate you because your firm is one of the top law firm in the country, and it has made name, fame even in international level also, for which, yes, on behalf of my teacher, it is my opinion, we always teach in the classroom vicarious liability. Why don't we take vicarious satisfaction in your success? We all take that satisfaction for which really we are all indebted to you people because you have achieved in your own field. Thank you very much for accepting our invitation, Srinivas ji. Please do come, do visit our institution again.
My pleasure, sir. Thank you for giving me this opportunity.
Yes.
Sir, I also, from the bottom of my heart, thank you for this wonderful session. I think our students have taken, great to their home. And with this, I thank you once again.
Go for next session.
So I ask Pratibha Madam to share the next session. Yes. So before thanking all, so the next session is on 30th of this month, same timing, 7 p.m. to 8 p.m. So session will be delivered by Shalmala, one of the alumni and advocate. The session is going to be on labor law, an insight into the laws relating to PF, Provident Fund. So I expect same cooperation, and more and more students can, and also lawyers can take advantage of this session and make it a grand success as today's. With this, I once again thank Srinivas ji for taking, in your amidst of your busy schedule, you have given a lot of time to us. We'll be great indebted to you. And also, I extend my thanks to our Professor Kempegoda sir for arranging this beautiful seminar. And also, I thank everybody, especially the team, along with Kempegoda sir and the technical team, and all my friends, alumni, and my lawyer friends and others for this session. And good evening once again. So we can end the session. Thank you.
Thank you, Ravindra. You've been a great host of both online and offline. Thank you.
We'll continue to be. Thank you.
Thanks,
so
Srinivas.
much.
Thank you, friends, all of you for joining. Thank you.
So
Thanks, Srinivas. Bye.